At 8:30? Good morning, nice to see you guys. Come on up.
Good morning.
All right, good morning. We have court reporter at 8:30?
Yes,
Good
ma'am.
morning.
Yes,
How are you? Good morning. Very nice to see everyone this morning. And we do have the camera. I told them that they can make an announcement. We're putting all these hearings on YouTube, so as well, and they'll be available for people to be able to see. So small, pretty for the camera. We're here in Wadsworth versus Tabio. Could counsel please see if their appearances for the record?
Good morning, Your Honor. Edward Ricci for Shannon Wadsworth, and Boris Jadanovsky is with me today.
Morning.
Good morning, Your Honor. Edward O'Sheehan, Shetland Bone of Geico.
Good morning. It's very nice to see everyone this morning. We are here on the motions for summary judgment. For the record, I had a chance to read the Geico's motion for summary judgment. I also read and received plaintiff's written response in opposition to the motion for summary judgment as well, and all the materials in support thereof. I want to commend all counsel for an excellent, excellent job in your written papers. Thank you very, very much. You may proceed when you're ready, counsel.
Thank you, Your Honor. Just from a quick housekeeping matter, since we've got competing motions, would it make sense if I make our primary argument, then they can go, and then Mr.
Absolutely.
Jadanovsky would like to do a rebuttal?
That's perfect. That sounds like an excellent plan. Thank you, Mr. Ricci.
Thank you. Your Honor, there's a narrow, distinct issue that's before you today, and the question is whether Geico's online waiver process complies with the statutory requirements of Florida Statute 627.727. This is a case that's simply a question of notice.
Exactly.
And, Your Honor, as a matter of law, there are no material facts that are in dispute. As a matter of law, it does not comply. The Jervis case is nearly identical to the issues that are before the court here today.
And I intended to ask Geico's counsel about that case out of the recent case out of the fourth. Absolutely. So.
And, Your Honor, in that case, it was a similar situation where an insured was online in order to bind coverage. And in that particular case, the 4th District Court of Appeal found that, as a matter of law, that the online process did not comply with the strict statutory requirements of the statute because the online process did not conspicuously display the notice language which is required under the statute. Similarly, in this case, I'm sure Your Honor has seen from the attachments that as Ms. Wadsworth went through the process, the M9 form, which we don't dispute that the form itself was approved by the Department of Insurance, that's really not the issue. The issue is, well, was it displayed to her? Was it furnished to her? It was not. It was behind a hyperlink.
And that was going to be my question for you, Mr. Ricci, because Geico's response is the Jervis decision is different in this situation since the M9 form in that case, or the M9 form was a prior version, an older version, and had defects that we don't have here. So how do we is there a way to distinguish that case as Geico's?
Yes, Your Honor. In reading Jervis, that doesn't seem to be really what the case turned on. The case didn't turn on whether the M9 complied. It turned on the fact that the form itself was behind a hyperlink.
Okay.
It was not conspicuously put in front of the insured so that the insured would see the required language, which is very specific, in terms of font and what it needs to say. And so we think that that's really a distinction without a difference because Jervis really turned on the fact that the form was never displayed and that it was behind a hyperlink.
Okay.
And I would just point out that...
The other question I was going to ask you is
Yes,
the
sir.
cases that Geico's citing in support of their summary judgment. There's some older cases out of the fourth, including, I guess it's the Mike Leiter case, and O'Brien certainly is older. How do I deal with that line of cases then, too?
Well, Your Honor, I think that, Jervis is a 2018 case.
Okay.
It just came out in April of last year, so we're almost near the one-year anniversary here. And, Your Honor, I don't think that those cases really speak as much to the issue of this online process like Jarvis does. We know from the testimony of the Geico corporate representative, John Haline, that it's undisputed. Miss Wadsworth never clicked on the link. If you look at the wording of the link, it doesn't say anything about waiver. There's really nothing for, as someone going through this process, that they're going to know, and that it was conspicuously displayed in any way that she was waiving her right to purchase stacked coverage. And I would just, I think it's important to look at sort of the public policy behind this. I mean, the Florida legislature clearly thinks it is important for insureds to have uninsured motorist coverage, and that's why they require that UM coverage be sold with bodily injury, along with bodily injury coverage. And if an insurance company is going to, charge a lesser premium for either non-stacked or no UM, then they have to follow a very strict process, which was not followed here. I mean, GEICO has since changed the process to display the M9 form, but at the time that this was at issue, the process simply did not comply. I would lastly just want to say that, as Judge Gross says, and the Jervis opinion, he says, to the average insurance consumer, thinking about stacking is as enjoyable as a dramatic reading from the Internal Revenue Code. I mean, this is not something that ordinary folks have really any knowledge of, and that's why it's so important that the insurance company comply with the statute. If they do not comply with the statute, then as a matter of law, then Ms. Wadsworth is entitled to UM coverage. And I think we'll hear a number of arguments, oh, well, that seems unfair because she wasn't charged a premium. We'll hear that, oh, well, she made a phone call on a certain date, and there's a dispute about what happened on certain phone calls at certain times. But in Jervis, they said that the trial court should have entered a summary judgment even on the issue of oral waiver.
Correct.
And so, whether the date of the call is frankly immaterial, the color of the button that she clicked on the website really doesn't have anything to do with notice. Whether the M9 was approved by the Department of Insurance has nothing to do with this because she never saw it. We know she never saw it. It was never displayed to her. And we don't dispute that an electronic signature is one way that someone could sign a contract. The problem is that they didn't comply with the statute, and they put the form behind a hyperlink. The 4th DCA has said that just doesn't comply with the statute, and without proper notice, the notice is void, and so she's entitled to statute.
Thank you so much. Response, please.
Your Honor, a lot of talk about complying with the statute, so I'm going to go with the statute.
Sure, and statute obviously is paramount, but I certainly want you to walk me through the analysis of Jervis. Is it distinguishable on the facts in terms of the M9 specifically used? How do I address that most recent line of controlling authority out of the 4th DCA?
Well, Your Honor, after the Jervis case, Perez was decided on the 3rd DCA, which came to a different conclusion. But talking about the statute, what Jervis holds is that the record in this case is that GEICO's notice was void, which means that in the eyes of the law that there was no 627 notice at all. Without such notice, there can be no informed and knowing acceptance of the limitations on stacking. And they got to that. The 4th DCA didn't decide that. The trial court decided that.
Correct.
And GEICO never appealed that. So that is a determination by the trial court there. So that's a legal issue, that GEICO never appealed that issue.
Okay.
And Your Honor, yes, it is factually distinguishable because I've got both. I've got the Jervis M9 here, and I've got, which was the 1996 version. And the 1996 version was also in the Perez case. And the Perez case said because of the problem with...
Does that matter? Does the specific difference in the M9 make any difference? Is that a distinction, difference without a distinction?
No, Your Honor, it matters because they said that the form is void.
Okay.
And because of the statutory language, the problem with it, the 3rd DCA said you get a knowing rejection trial. Our position would be that the 3rd DCA, if we had the 2013 form down there, the 3rd DCA would have granted us summary judgment. The issue of complying with the statute, I just want to take one step back, public policy. UM is not required. The legislature could have required UM. In many states, UM is required. In Florida, you've got to get 10, 20,
Sure.
and that's it. So, the argument that, it's so important to the legislature, what the legislature in Florida, who writes the laws that control us, decided is that UM is optional. People, consumers, can decide, do they want it or do they not want it? But they did say, if you're going to buy bodily injury coverage, You can't get UM and protect yourself unless you're going to get BI to protect others. So if you're going to get BI, then you are eligible to get UM. And what the 1982 amendment, and I'm reading now from 627, basically says if you're going to sell with BI, you've got to have UM. And then it goes on to say, quote, however...
But let me just ask you, you agree with me that Jervis is still good law, and that's controlling on this court as opposed to the case law of the third, right? I mean, I can't avoid that. Jervis is controlling on this court.
Yes, Your Honor, but Jervis didn't talk about a hyperlink, and we've got a case law I'd like to show to you. And I would say Jervis is a trial court decision that the fourth just reiterated what the trial court said.
But the fourth did not reverse the summary judgment. I mean, so it's binding on this, it's binding authority. I cannot avoid Jervis, right?
But Jervis didn't, and I've got hyperlink case law that I'd like to show to you.
Okay.
Jervis did not talk about the hyperlink. Jervis did not point out in one manner how this procedure, how GEICO's procedure doesn't comply with the statute. Because what the statute says, quote, however, the coverage required under this section is not applicable when or to the extent that an insured named in the policy makes a written rejection of the coverage on behalf of all insured under the policy. And I would say to Your Honor that in this case, in Jervis and in Perez, the insurance company, GEICO, had a written rejection from the insured, from a named insured. So we've got that here. So we're being told we don't comply with the statute. The statute says we've got to provide that insurance.
How do you comply with the statute?
Because we don't have to provide that insurance if we have a written rejection signed by a named insured. And we've got that written rejection signed by a named insured.
Okay. Anything else on your rebuttal?
Yeah, I'd like to present Your Honor with two cases that we refer to. One is actually the fourth DCA case. It's Leatherwood versus Card Service International.
Okay. I'll go back and read that again. I've already read it, but that's fine.
You know, basically saying that if you click agreements, if you click go on the internet, if you click I agree, then you're bound by that.
Okay.
So that's fourth DCA saying that's proper. GEICO's procedure took you through, if you've looked at our exhibits, the person came to a page. I'm sorry, Your Honor. I'd just like to read some language off of the actual page that the person
Okay.
viewed. So the page where the hyperlink was and where at the bottom where you click I agree, starts off saying read, and review, and sign. It says please review the forms below that require your electronic signature. And before you got there, you went through a series of consent pages that comply with federal law and state law. Next line says you can review your chosen selections and options by clicking on the form link below. In the form link below, everything is in black, but the link is blue. It's in the middle of the page. It's not like there's some cases hold if the terms and services that you're being bound to are, you got to scroll down and they're hidden. That may not be enough
Okay.
notice.
And what's the second case? I'm going to go back and look at it because we're running short on time.
Okay. But here, my point is GEICO was telling the person to review, and the person by clicking certified that they had reviewed and understood.
Okay.
The second case is Metro PCS, recent case out of the third DCA.
Got it.
It's a Westlaw site, 2018 WL 6786813.
Okay.
In that case, the question had to do with whether somebody was bound by an arbitration provision that was behind a hyperlink. And so the key issue in most cases involving electronic contract formation is notice and manifestation of assent. A click wrap agreement occurs when a website directs the purchaser to the terms and conditions of the sale and requires the purchaser to click a box to acknowledge that they have read those terms and conditions. And our page, that's exactly what it does. The third DCA here, and it was undisputed, same as our fact of Ms. Wadsworth, she did not look at it. GEICO's records show that she didn't click it and look at it. In this case, the Metro PCS versus Porter also didn't look at the hyperlink.
Is that an analogous case? We're not talking about the same statute at issue. Arbitration is a different analysis. Public policy favors arbitration. I don't know that that case is necessarily applicable in this situation in terms of insurance contracts versus arbitration agreements. when we have a whole body of case law that says we favor arbitrations, those types of things. So I don't know I think that case might be an opposite in this
Your
situation.
Honor, I assert that it's not, because there's nothing at all in 627, 727 about electronic contracting, about hyperlinks. The Jervis case doesn't refer to hyperlink. And here in the Metro PCS case, they say Porter simply chose not to click on the hyperlink. And quote, a person has no right to shut his eyes or ears to avoid information and then say he has no notice. And that goes back to a 1932 Florida case. I mean, whether it was a hyperlink or if somebody came into, it could have been an in-person transaction. She could have come in and handed the form. There's no way Geico or anybody can force somebody to read a contract. In the statute...
Let me just ask you, and I'm going to turn it over for rebuttal. Is it your position that what happened in the situation is that Geico followed the statute, yes or no?
There's our position that there's no statutory provision that was violated. Electronic
So you're saying
transaction.
yes, the statute was fully complied with?
There's our position that Jervis has not pointed out any section of the statute specifically that was not complied with, and in this case, their summary judgment evidence hasn't pointed out any portion of the statute that was not complied with. And going back, we're at the procedural stage of summary judgment. The affidavit in support, they say this all took place on May 31st, 2015.
Yes.
The records that you've been provided from Geico, the electronic records of phone calls and her going online and Geico's people going online, show that the address change happened on May 15th. Nothing happened at all with regard, on May 16th, she got a new declaration page, Exhibit 10 to Mr. Smith's affidavit, showing her address had been updated to Boca Raton, which increased her rates.
Okay.
2 weeks later is when she has these phone calls. She goes online twice and has phone calls, and that's when the gets rejected.
All right, thank you so much. Rebuttal, please.
Your Honor, I'm going to be very brief just because I understand we're running out of time. I'm not going to paraphrase what Mr. Ricci has said, just dealing with three quick issues. The first contention that Jervis did not deal with this hyperlink issue. It only dealt with a missing word, the word liability in the top. Looking at defendant's own motion for summary judgment, they list a couple cases such as White v. Allstate and LaRusso, one of which being a fourth district decision that says technical issues would not have thrown out the plaintiff's case. So more or less this contention that this one word difference is the reason that Jervis was decided the way it was decided just doesn't seem to flow with the remainder of the decisions that were cited by the defense.
Okay.
The second contention is all this arguments about click wrap agreements, arbitrations, anything else, mortgages. All of those are not the same and not analogous to this.
Well, that's what I was asking you. This is a statute. There's different public policy and arbitration proceedings.
Yeah, and there's plenty of case law where the public policy in this case is actually different. The public policy in this case favors UM coverage.
Okay.
That's why the insurance company has to go through these hoops to have a insured reject UM coverage. The Jervis court counted 9 shalls in what the insurance company has to do in their M9 form.
Okay.
We're not contending that they didn't do that in this case, but it goes to show what the insurance company has to do. And the burden is on the insurance company to prove that there was a knowing notice given and a knowing rejection of the UM coverage, which they've simply failed to do. And the third contention is, as Enrique pointed out, these straw man arguments that there's other facts that potentially are a little muddied. However, those are not material facts of the issue. The material fact is what occurred on May 31st when Ms. Wadsworth went online and went through the screens.
Okay.
And you went through the screens with opposing counsel. And if you look, Geico had the ability to present the whole form, as they did on the previous page,
Okay.
because it's federally required that they do so. However, they failed to follow state law and give a mandatory notice of UM.
Okay.
And why did they do that? On opposing John Julio, they're trying to streamline the process for different states. Obviously, the federal form is the same in every state. However, those hyperlinks
Okay.
are different in other states. They were trying to circumvent the system.
Okay.
And this is why we're here.
Wonderful. Excellent job on both sides. What I'm going to do is I'm going to do a detailed written order for all counsel. Can counsel send me a copy of the transcript from the hearing as well when you get a chance after you order it?
We have
Oh, very,
30
very,
seconds.
just very briefly,
Just
counsel.
to finish, the Metro PCA cites a recent case dealing with Uber and just electronic transactions. It says, where there is no evidence that the offeree had actual notice of the terms of the agreement, The offeree will still be bound by the agreement if a reasonably prudent user would have been on inquiry notice of the terms. So just going to electronic commerce, the Florida version of the Electronic Commerce Act says insurance transactions are included in that. There's nothing in Chapter 627 that requires the form to be displayed. There's nothing that, the fact that it wasn't displayed is not a violation of Chapter 627 because that's not a requirement. And going to state law, the reason, and there's case law, and we cited it in our briefs, the reason these amendments came about and it required the written rejection was to benefit insurance companies. Because there are all these cases pre-1982 and 84 where people would not reject and then they get an accident and then they say we want it, and everything had to go to a jury trial because there was one person's word against the insurance company. So they came up with this written requirement in 1982. A few years later, in 84, they said, all right, now it's got to be a form approved by the Department of Insurance. And the whole reason was so the insurance company could get that statutory conclusive presumption.
Thank you so much, council. Have a great day, everyone. Thank you all so much. All right, let me go ahead and start motion calendar. Excellent job. Let me go ahead and start motion calendar. First up, I have Vicuri versus Angelo and Corvia, please. Motion for attorney's fees. Council, ready to do the court order?
Good morning, Your Honor.
Do the court order? No? Okay, all right. Good morning. This is Vicuri versus Angelo and Corvia, and this is a motion for attorney's fees and costs in response, in filing in response in opposition to defendant's motion for summary judgment. And you may proceed when you're ready.
Yes, Energy Katia on behalf of Ms. Vicuri. So, Your Honor, we filed our response to motion for summary judgment, which later was withdrawn by defendant.
Yes.
In our motion for attorney fees, we are seeking costs that we incurred
How can I get costs in response to a summary judgment?
because the affidavits were presented in bad faith.
I have to make a determination, a legal determination of bad faith then. I can't just grant attorney's fees. Your motion's denied. I have to make an evidentiary finding. Bad faith has to be proven by clear and convincing evidence. It has to be done at an evidentiary hearing. I have to have testimony. So I'm so sorry, your motion's denied without prejudice.
But one of the experts was out of state expert, did not testify.
But then you should have stricken it. But again, I have to make a bad faith finding, and bad faith has to be determined by clear and convincing evidence. That it gets reversed on appeal all the time. Your motion's denied without prejudice. Okay, and we have to strictly comply with the case law in this court. All right, thank you guys. Have a great day. Okay, Asher versus Asher, please. Motion to dismiss, Councilman.
Good morning, Your Honor.
Good morning.
We're trying to work this out.
Oh,
Opposing counsel's outside.
Take your time. Not a problem. Take your time. Thank you, Mr. Lemoyne. Shar versus Tower Hill Select, please. Motion to dismiss.
I am here on that,
Okay,
Judge.
wonderful. As soon as court report's ready, let me know. All right, good morning. All right, good morning, everyone. Here's Shore versus Tower Hill. Could counsel please state their appearances for the record?
Sure. Good morning, Judge. Nicole Suzette Clark, for the defendant, Tower Hill.
Good morning, Your Honor. Brian Paris on behalf of the plaintiffs, Mr. Gary Shore and Roofing Analytics.
Good morning. It's very nice to see everyone this morning. We're here in defendant's motion to dismiss the Tower Hill's motion to dismiss. And I had a chance to read the motion. You may proceed with additional argument at this time.
Sure, Judge. So we have a very simple set of facts, somewhat of an interesting statement issue.
Yeah.
So the case stems from roofing damage to the insured's property as a result of Irma. The insured called the roofing company to do some work. They signed an assignment of benefits. The insured was not happy with the insurance company's decision, and now there's a lawsuit.
Yes.
The issue here, Judge, is that now we have a lawsuit that's being brought on behalf of both the insured and on behalf of the roofing company as assignee of the insured.
Yes.
So if we're taking the allegations of the complaint as true, then we're to believe that there is a valid assignment of benefits, meaning that now the roofing company has the right to
shoes.
correct.
Yeah.
Now, if we're taking that as true, then the insured no longer has.
Yeah. Who's got the right to bring this lawsuit? Is it the insured or the roofing company?
And, Your Honor, we do have a position on the issue, but simply put, for the purposes of today's motion, we've pled this case in the alternative.
You can't do that. Can't bring two things. Who's suing?
If I can just
Yeah.
explain, the issue that's inevitably going to arise is the question of the validity of the assignment of benefits. And even in looking at defendant's own motion, you can see that...
You gotta bring one. You can't bring both. So I'm gonna grant the motion to dismiss. You're gonna have to amend to have one party.
Your Honor, if I may.
Yeah.
Just for a little bit more clarification, once the complaint is amended, there are other issues in the complaint. So for instance, there weren't any damages alleged.
Yeah.
So if,
I know council's going to go back and address these other issues, but you can't bring two separate parties. Who's got the right? Who's got the claim?
And Judge, our position generally is that the assignee does have the
Then
issue.
sue for the assignee.
The problem is we anticipate there's going to be a motion to challenge the validity of the assignment. So
And we'll deal with it at the time.
from our position, this motion is simply premature. It's an issue that should be flushed
No,
out.
absolutely not. Motion dismisses granted. How much time do you need to amend?
If I can have 20 days, Your Honor.
20 days it is.
Sure.
All right, thank you guys.
Thank
Can we
you.
submit an order?
Electronically. Thank you guys.
Thank you, Judge.
All right, let me go ahead and do Bridgeview Association versus Turkin, please. Motion to strike affirmative defense. All right. Are both sides here? You're waiting for the other side?
I believe so, Your Honor.
Do you know where they are?
I don't.
All right, do you want to call them and see if they're
Sure,
in the
yeah, I'll
Wonderful.
call them.
Thank you so much. Let me please go ahead and do Calvo Focali versus Bauman, please. Motion to dismiss.
Judgment on that one.
Okay. All right.
Morning, Judge.
Go ahead. We are here on, we're just waiting for counsel. All right, this is Calvo Focali versus Bauman. Could counsel please state their appearances for the record?
Good morning, Your Honor. Leon Hunt on behalf of the plaintiff.
James Sarin from McIntosh Sarin here on behalf of Daniel Lewis.
Good morning. Very nice to see everyone this morning. We are here on defendant's motion to dismiss plaintiff's amended complaint,
Yes,
and I
ma'am.
got a chance to read your motion. You may proceed with argument when you're ready, counsel.
Thank you, Your Honor. Judge, we were here back on January the 30th of this year.
Yes.
On a motion to dismiss. We asked the complaint be dismissed with prejudice. We set out in a memorandum of law the reasons. The court, if you recall, this is the bicycle riding
I
by
did.
on the street,
Yes.
dog behind the fence. The court indicated to plaintiff's counsel quite clearly that there were some serious issues with causation. That has not changed, Your Honor, since January the 30th when you dismissed this complaint. They have amended. They've made 2 slight changes in their complaint. They have still not stated a cause of action under the existing statutory and case law that we cited in the initial motion to dismiss. They simply allege without foundation that there is causation in paragraph 10. They also just add or change one of the allegations that rather than Ms. Calvo running into a garbage can on her bicycle, she ran into an obstruction. That doesn't change anything, Your Honor. We are still firmly of the belief that there is not a cause of action stated
My only,
under strict liability or negligence.
my only question is, okay, let me hear a response first of all.
So, Your Honor, as counsel stated last time we were before Your Honor, there was an issue as to causation, which I would note completely moved the goalpost. That was not mentioned at all in the motion that was filed by the defense counsel. However, at Your Honor's instruction, what we did was went back, we looked at the case law, and Your Honor, the language that is in paragraph 10 is taken directly from a controlling case on the matter. The site is Brandeis v. Felcher, 211 Southern 2nd, 606, 1968. It's a 3rd DCA case. And Your Honor, that case discusses causation in a situation with strikingly similar facts. There was a child riding by a home. A dog runs up to the fence, begins barking, jumps on the fence. The child, out of fear, runs into the street and is hit by a car. And in that situation, although it was a motion for summary judgment, the issue was the defense was questioning whether or not the plaintiffs could prove causation. And the court stated that there was enough to prove causation and that it was a matter for the jury.
Okay.
So if the court held that there was enough to prove causation under that language for a jury, surely there's enough for the defense to respond.
Okay, rebuttal please.
Judge, the rebuttal is quite clearly under the Jones case, which is the Florida Supreme Court case. In order to prove causation, plaintiff has to show that there's some affirmative, aggressive act by the dog that's not been pled here. And clearly the Jones case stands for the proposition that the Florida legislature never intended the strict liability statute under 767 to make a dog owner responsible for every injury.
That's the part I was having trouble with last time. What does the dog do here?
So, Your Honor, and again, that's pled in the complaint, paragraph 9, and I have copies for Your
No,
Honor.
I read it. Just tell me what the dog did.
Specifically, the dog, as Ms. Foucault was passing by the house or by the yard, starts barking and begins charging at Ms. Foucault.
Okay.
And it's also alleged in the complaint that Ms. Foucault had had previous experiences with this dog, including video footage of the dog leaving the property.
Okay.
And there are there's argument from the defense that Ms. Foucault never saw the dog. But again, the standard in a motion to dismiss is the four corners of the complaint.
All right, I'm going to deny the motion to dismiss. Why don't we re-raise these issues at the time of summary judgment then? Because I think they've at least they've pled more than they did last time. How much time do you need to answer the complaint?
10 days, Judge.
All right, 10 days it is then.
Thank you, Judge.
Thank you all so much. All right, you have the team ready?
We have an agreed order.
Oh, wonderful, thank you. Thank you, Mr. Lamar.
Have a great day.
Have a great day. All right, let me go ahead and did you find your present counsel?
Yes, Your Honor. She calendared it. She said she would agree to an order striking, giving her 10 days to apply.
Perfect, just hand up a copy of it. Wonderful, thank you so much. Have a great day then. Let me go ahead and please do Gagnon versus Universal Property, please.
It should jump on that one.
Wonderful. All right, good morning. Good morning, everyone. This is Gagnon versus Universal Property. We have a court reporter. If counsel could please state their appearances for the record.
Kevin Guerrero on behalf of the plaintiff.
Melissa Jordan on behalf of the defendant Universal Property and County.
Good morning. Nice to see everyone. This is an amended motion to compel compliance with the subpoena justice tecum of the corporate rep and for sanctions. And I read your motion. You may proceed, counsel.
Well, Your Honor, basically we're asking for a second deposition because the first one, and I was there for the first one, was a complete sham.
Okay.
Ian Ronderos, which was the opposing counsel that was there, counseling the defendant's corporate representative, he needed about 30 minutes even before we started because it was her first deposition, Your Honor.
Okay.
And she was completely unprepared. She didn't know the answers to simple yes and no questions, which are extremely relevant to this case.
Yeah.
And on top of that, Ian Ronderos, as seen in the attached transcript, instructed them not to answer on several relevant questions.
We don't do that. We don't instruct witnesses not to answer in a deposition, counsel, right?
Your Honor, if I may,
Sure.
can I ask if Your Honor received our response?
I did, but we don't instruct witnesses not to answer.
Well,
Right.
Your Honor, we do have the ability to instruct them not to answer if it goes to protected privilege.
Which privilege did it go to?
It went to both, in a lot of these circumstances, it either went to work product, attorney-client privilege, or part of the internal claims handling, which isn't amenable to discovery at this process. because
Every
it's a
single one of
breach
those
contract.
questions go to privilege?
Correct, Your Honor.
Okay, well, we can walk through that analysis then
Yes, Your Honor.
specifically. So which one are you claiming didn't go to privilege?
Your Honor, we highlighted
Yeah.
all of them inside of the motion.
Yeah, so let's go through walk by step, one by one.
Sure, Your Honor.
That's the first question.
Sure, Your Honor, and we highlighted each of them in our response.
Yeah.
Your Honor, in the first one, which goes to questions about bad faith discovery, asking, are you familiar with the Adjuster's Code of Ethics, which is a law in Florida? And he instructed not to answer.
That's not privileged.
That's a yes or no
That's
answer.
a yes or no. How's that privileged in any way? Are you familiar with the law? How
Yeah,
is that privileged?
well, because, Your Honor, that goes directly to an issue of the bad faith handling, which, Your Honor.
Ma'am, that's a no. That as a yes or no. Are you familiar with the law? That's not privileged.
Well, Your Honor, if I may, just respectfully, that one of the issues that we have here is that there was an entire line of questioning that went into
That question, there should have been no instruction not to answer. So I'm striking the response. You're going to have to sit for another deposition just for that question alone. We don't instruct witnesses not to answer questions.
And Your Honor, if I may, just one of the cases that I just wanted to bring to Your Honor's attention is a 4th District Court of Appeal case, Citizens Property Insurance Corporation versus Mendoza.
Okay.
The site is 250 SO 3D 716, where it even advises in that case that it's not proper to be addressing the Code of Ethics and whether or not an adjuster properly or improperly is
I
handling
have
the
a copy of
case.
that case. I'm happy to take a look at it.
Yes.
So, but that's still not privileged. That's the point. They should have answered. It may not be relevant. It may not come in front of the jury, but you don't instruct a witness not to answer.
Well, and that's the other point, Your Honor, is that it was completely outside the scope of the discovery.
Ma'am, motion to compel is granted. Your witness is going to have to show up. Next time you have a problem in a deposition, just pick up the phone and call me.
And Your Honor, if I may, of just the other instructions, I just want to make sure that then if the court would be granting in regards to that respect, that many of the other ones have nothing to do with anything that's relevant.
Relevance is not an objection.
No, I understand, it's not about relevance, it all goes to bad faith claims handling. And that's why, Your Honor, if I may, of just, Your Honor, for the purpose of deponent being called back to go for a second bite at the apple, of just it being extremely limited to the specific questions that would be at issue in this.
Bad faith is not an issue at this point. So you're not going to get in any bad faith.
We're not
What I'm going to
getting-
do is I'm going to require the witness to appear for deposition again. I'm going to reserve as to fees and costs.
Thank you, Your
All
Honor.
right, yes.
Your Honor, if I just may ask, can they be limited just to the questions that My problem is just that if they're going to retake an entire deposition, I don't want.
They never should have done this correctly. You're lucky that I'm not sanctioning them. Okay?
Thank
They
you.
need to, we don't instruct witnesses not to answer during deposition. It's not appropriate unless it's specifically privileged. And a yes or no answer, whether they're familiar with the law, is not privileged. So they need to know better. I don't tolerate this kind of behavior.
Thank you.
All right, thank you.
Thank you, Your Honor.
We'll submit an order online.
All right, thank you so much. Deutsche Bank versus Gente, please motion for summary judgment foreclosure. Counsel ready?
Yes,
All right, good morning. This is your motion for summary judgment. And I read your motion. Anything to add to your motion?
No, everybody's been defaulted already.
That's fine. Everything looks good. When would you like your sale date?
This one's as soon as possible.
Okay, 35 days, Michelle, sale date. Perfect. Thank you so
Madam
much.
Clerk?
Yeah, just hand it to Michelle. Thank you so much. Long versus Mar-a-Lago Club, please. Counsel ready? Court clerk?
Good morning, Your Honor.
Good morning, guys.
I believe plaintiff's counsel's on the phone.
Oh, I just need a phone number. Do you have a number to call?
Should I? I'm sorry.
It's okay.
If you want to
I
take
remember
somebody
call? That's
else,
fine.
let me
Not
do
a
that.
problem.
I'm sorry.
Okay. Not a problem. I just don't know what number to call. I
Yeah,
have a couple-
let me get that and then
Okay,
we'll.
wonderful. I have a couple case management conferences. Kaufman versus Coulter. Your team ready on Kaufman versus Coulter? No? Federated National versus Gazeta. Counsel ready? All right, good morning.
Good
All right, good
morning.
morning. And what is the status of this case, counsel?
Good morning, Your Honor. We have a pending motion for default judgment. I do have opposing counsel. They said that they'd call in.
Okay, that's
Or
fine.
have their phone number.
Why don't we set the motion for default judgment for hearing?
Okay.
That's all you need to do.
Okay,
Set it for hearing within the next 20 days.
sounds good.
All right, wonderful.
Your
Thank you so
Honor.
much. Savicus versus Pelican Harbor. Counsel ready?
Your Honor.
All right, good morning.
The opposing counsel's in Orlando. I have a
Yeah,
phone
we
number.
call. Thank you so much. Wonderful. Thank you.
And may I leave that?
Wonderful.
Thank you.
Okay, thank you. Okay, right.
The number you are trying to call is not reachable.
Okay. Oh, Counsel, good morning. This is Judge Sasser. Are you ready on the status conference hearing in Savicus versus Pelican Harbor?
Yes, I am.
Wonderful. And counsel's here in the courtop's What's the status of the case?
Status of the case is we're doing some discovery.
Okay.
The pleadings are technically an issue, but opposing counsel and I have had some discussion about there may be an amendment to the affirmative defenses in the works. It took us some time to get some engineering plans from the city of Delray Beach,
Okay.
which has caused a slight delay. Now that I have them, I've shared them with opposing counsel.
Okay.
They're a little fuzzy. We're waiting for the engineers to tell us what's what.
Not a problem. Then so I'll do 90-day status conference. Hopefully you'll get the plans taken care of. Take care of the amendment if you need to, and then I'll set you for trial. Wonderful. Thank you guys. Have a great day, everyone.
Thank you.
So Michelle, 90-day status conference. Here's the order on that one. You can fill it out. All right, let me go ahead and do Bobenarth versus Home Depot.
And I do have the number for.
Okay, let me just do the Home Depot and then I'll call you guys next.
Judge, I've got another
Home Depot. Okay.
Morning, Your
Good
Honor.
morning, guys. Go ahead.
Go ahead, Your Honor. Thank you, sir.
All right, are you guys going to be a while because we got interrogatories and I have to do another hearing, so.
Correct. Your Honor, Corey's request to produce. We have the expert depot set for 4:30.
Okay,
First
all right.
one.
Okay, all right, let's go ahead, let me go ahead and go to the record. We're here in Bobenarth versus Home Depot. Could counsel please state their appearances for the record?
Correct, Your Honor. Gary Sasser on behalf of the plaintiff.
Andrew Socha on behalf of the defendants, Your Honor.
Okay. All right, we have a couple of discovery motions, responses to expert interrogatories and requests for production.
Correct, Your Honor. Key, we followed this as an emergency motion last week because the deposition of Dr. Grable set today for 4:30.
Okay.
We cannot proceed to be prepared for deposition unless we have proper answers and the request to produce. Late last night, I was at another deposition on this case in Port St. Lucie. defense file amended answers, which are still, we believe, insufficient. I have a copy of those, if the court does not have them yet.
No, I have everything. So
I have a
let me
copy.
just ask you, have you had a chance to meet and confer on them?
And what we did was, I spoke to Mr. Sasser, I believe, a couple days ago, and
Okay.
there were a couple issues that I told him I was going to amend and supplement, which I certainly did.
Okay.
Your Honor, it's our position in general, and I do have the case with me,
Okay.
that expert request for production is actually improper.
It is.
In regards to the
Yeah,
rule
we don't do that sort
and
of
the case
request for
law.
production. No, we don't do that, so.
So in regards to my objections to our
Yeah,
request
generally,
for
I have to
production.
sustain those. We don't do that.
Your Honor, I understand that, but what we asked for in our request for production is directed to the defendant and the law firm. We asked for copies of the bills, we asked for copies of the correspondence, we
We
asked
don't
for
give it to
the...
the expert. That's the only thing. So I have to sustain defense objections.
We directed these essentially to the defendants, Your Honor, not to the expert.
These are expert
They're
requests for
expert- they're
production.
expert
Judge.
Well, they're pertaining to the relationship with the experts.
Can't do it that way. You gotta do it together.
And in addition, Your Honor, the doctor today is obviously going to bring his entire file with him.
Very well, bring your
Have-
file. Do you want it in advance? Maybe you can get there early and take a look at Dr. Rabel's file in advance?
I'm going to have to do that, Your Honor, even though I have another court proceeding at 11 o'clock.
Okay.
Because it's unfair to sit there and do it
I
at
just
the last
can't- I
minute.
can't- yeah,
Then we
I
go
can't.
to the interrogatories, Your
I'll get to the
Honor.
interrogatories, yeah.
Because, they're segued right there. I mean, they started with 7 experts, they're down to 5.
Okay.
And we've listed which one which means.
Yeah, they're gonna say which ones are calling.
Right.
Correct. We asked for copies of, in interrogatories, the documents reviewed.
Yeah.
Okay? We don't have that, okay? For Grable, they're going to sit there and say, okay, I'm looking at this file now, I can come early and do that. But what about the other 5 or 4 experts they're
Do
going
we have a
to use?
response to that one, counsel?
Yes, Your Honor, and what I'm going to do is, actually, I believe what Mr. Sasser just said is again requesting documents, which is.
You don't do that from the experts, but you're gonna disclose what you reviewed, right?
Correct, exactly.
Okay.
And again, today at the deposition, all the documents reviewed will be in the file.
And you do that for the other
So
experts?
that's not a
too?
problem, exactly.
Okay. All right, then, I'm gonna require that in advance of all the other experts.
That's fine.
And that's interrogatory number 4, Your Honor. Then we go to interrogatory, I believe, 6E.
Okay.
We asked for the information as to what work they've done in terms of conducting CMEs. Okay, and they object to that, so
Let me hear a response on the scene.
Well, Judge, what's being requested is examinations before the litigation process has ever started. So, I mean, according to the rule, we need to provide information regarding, looks like depositions, trial matters,
Yeah.
not pre-litigation
Yeah,
issues.
pre-litigation's
That's
not
not
required.
relevant. That's not relevant.
I agree.
And what we did was we provided what's required by the rule, the breakdown of the percentage of the work done for plaintiffs versus defendants for all of the experts, the overall expert work breakdown of percentage. So what's required by the rule, we have provided to opposing
Okay. All right, so what else is missing that you need, Mr. Sasser?
I'm sorry, Your Honor?
What else is missing that you need?
Number 8, that would be it, Your Honor.
Okay. All right, just number 8 then.
Number 8 is their fee schedules. We just got last night, I believe, the fee schedule for Dr. Grable.
Okay.
I don't believe, and
We
maybe...
provided Dr. Kramer as well, and we're in the process of getting all the others, and all the fee schedules will be given to opposing counsel.
Okay, great, wonderful.
And then, Your Honor, I would go to number 9.
Okay. All right, Mr. Number 9.
That is the amount of monies paid to each expert
Okay.
over the past 3 years. They did list, I believe, in response that there was monies paid to certain experts by this law firm.
Okay.
However, the answers to interrogatories were signed by a paralegal for, and if you look at the beginning of the answers to expert interrogatories, Your Honor, a paralegal, Tricia Brooks. Home Depot has insulated itself from discovery as best they could. What they've done is they started a separate LLC called Litigation Store Support Center. And what they've done now is saying, okay, you lawyers, you get the bills, you send them to us, we'll pay you, the lawyers, the bills. Okay? And basically adding an extra step into the litigation process.
Okay, but what else do you need on that, on number 8? What's missing? What's missing on number 8?
We don't have anything.
Okay, all right, any response?
Well, I believe you mean number 9.
Oh, okay, I don't
Yeah, so Judge, and I don't want to get too deeply into my client's
You don't.
law firm retention process, but the way that it works is each individual law firm pays for their own experts.
Okay.
So what I did was, and Home Depot doesn't keep a list of a total amount of experts, what I did was, I found what my client has paid each expert total over the last 3 years and gave that to opposing counsel.
Okay, yeah, because Home Depot doesn't maintain it, it's based upon law firm.
Correct.
What we're looking for, Your Honor, is the Home Depot relationship with the law firm and what they've been paying this law firm, these experts. And, to sit there and say that they've paid Dr. Grable over 3 years, $21,000, we believe
Does
is
Home
not
Depot not
accurate.
maintain how much Grable's been paid?
Not by every law firm that they retain, we have the information
Home Depot doesn't have how
from what
much,
our law
they
firm,
don't have how much was paid to Dr. Grable?
from our law firm that
Other
we
law
have the
firms.
information.
Other law
They
firms?
do not, because each individual law firm pays themselves. That's my understanding, and that's why they
Okay,
don't
so
have
they're saying they don't have
information.
that information.
Well, Your Honor, I understand that, and I heard that this morning. I think that's a bit
Then you
disingenuous.
need to be able to take Home Depot's corporate
Correct.
representation then. Okay, so just make your witness available for deposition on that issue. Because that's probably, if they don't have the records, then Home Depot's gonna have to testify as to the amount then.
Thank you, Your Honor. Number
Okay.
10, we asked you what was done in terms of retaining these experts and what was the discussion, what the discussion entailed. And they said in the revision last night, hey, these are the dates we first contacted them. Okay, partial answer. Where's the rest of the information? Who contacted them? What were the instructions? What was going on?
Judge, I mean, all we did was reach out and retain them on a certain date. So, I
Okay,
mean,
there's no other information that they
I
have.
don't really know what else is
Okay,
looking
all right, let's do the next one.
Number 12 is basically asking for the case list. We got it for Grable and Kramer. We're down.
Which expert are you missing for?
We've sent over Elkins
Okay,
this
so you should have Elkins for all
I
the
haven't seen that
experts.
yet. Did you send over the others?
You should have all of them. If not, you'll have them today.
Okay, great. All right, let's do the next one.
I believe, Your Honor,
Is that it?
number 14.
14, okay.
Okay, we asked for their opinions.
Okay,
And I said, go look at our expert witness list.
okay.
Or look at their reports. Well, I've got 2 reports
Okay, all right.
of the 5 experts.
Do it, are
and
any
they're-
other experts going to do reports?
I've given him every report that every expert's done
Okay,
in this
then the
case.
interrogatories needs to be answered then. Okay, so how much time do you need to answer that one?
Oh, so this is talking about reasonableness of medications
Yeah.
administered. So, again, it's a little bit vague as to what medications
If they have an
administered
opinion on it.
means. That's fine.
Okay.
I can supplement that, but
Your Honor.
That's fine, so this granted, motion compels granted. On that one,
Thank
number
in
14.
terms of 14.
Thank you for your time this morning.
Okay, thank you guys, have a great day.
Thank you, Judge.
That would be excused.
Yes, have a good day. All right, come on out please on Long versus Mar-a-Lago, please.
Thank you.
All right, and we have a phone number, so I'll call council.
I do. It's
Wonderful.
561
Got it.
444
444.
8822.
Wonderful.
And it's Tim Felice.
Okay, let me give him a call.
Good morning, Police Center. Nick, how can I help you?
Good morning, I'm trying to reach Attorney Tim Felice, please. This is Judge Sasser, I'm calling for the hearing on Long.
Sure. You're the judge?
Yes, ma'am.
Oh, okay, very good. 1 second. Okay, I'm gonna transfer you to Tim now.
All right, thank you.
Hello, this is Tim.
Good morning, Mr. Felice. I'm calling you on Long versus Mar-a-Lago, and we are set for hearing this morning a motion for enlargement of time to conduct the mediation. And I read your motion, you may proceed, counsel.
Okay, thank you, Your Honor. my motion is kind of self-explanatory. Basically, this case is not set for trial yet. We were here back in December, I think, at plaintiff's request that we set this for mediation. We had asked for about 90 days so that we could complete some some corporate rep discovery. That we were having some hard time scheduling. There were 2 scheduled. One was rescheduled at my request due to an emergency, which plaintiff's counsel readily accommodated.
That's not a problem.
So we had actually agreed. I think our co-defendant was inadvertently left off an email in which we said, hey, let's get some more time.
Sure.
And so we had agreed with plaintiff's counsel to kind of extend the time. There's no trial set. There's no real deadline. But my understanding is that our co-defendant is objecting to...
What's the basis for the extension for mediation?
I don't know what the basis is. This is all the correspondence my firm has produced, trying to get the mediation set.
Okay.
This is all the correspondence regarding my corporate representative deposition.
Okay.
We did everything that we could to move this case along.
Okay.
My client's deposition was set. I had him prepared. He came up from Miami. I spent 2 hours with him going through the entirety of the file. We're ready for trial.
Okay, I'm happy to set it. Someone just needs to send me notice. I'm happy to set it for trial, but I'm happy to extend the time for mediation. That's not a problem. You think maybe 60 days would be good?
I would say another 90 just because of scheduling issues and getting a mediator. So I think we could get the discovery and a mediation date within 90 days.
Okay, that sounds great. 90 days it is then. Okay. And then if you want to, I'm happy to set it for trial after that, if you guys want to. That's not a problem. Just tell me when you would like to go to trial. I'll set it whenever you want.
Thank you.
Okay, thank you guys. Have a great day. Motion's granted. Have a great day, everyone. Anybody else here for UMC? Come on up. Which case you guys here on? I don't have any paperwork. And I don't have your opposing counsel, so I can't hear your motion, sir. So, he's not here anymore. So, come on up. What case you guys here on? Okay.
Cohen versus the estate of Robert Zahn and
Got it. Okay. Do you have a court order? No? Okay, all right. You may proceed. I read your motion.
Your Honor, we noticed this case for trial. It's a 2017, it's a medical malpractice case.
Yes.
It's not particularly complex, but it is difficult because of the nature of the experts.
Sure.
We noticed the case for trial in February. We had a very quick response time. The day we got the trial order, we both spoke. It went from the end of February. It's set in May.
Okay.
There was just no possible way for us to set, and we asked the court to move us to November or December. We will be ready.
That's no problem. You guys can set an agreed order. You didn't need to come in. I'm happy to send you November or December. That's not a problem at all.
Okay.
Okay. We'll send you the trial order soon. Thank you guys. We're here to make your life as easy as possible, I promise. Okay.
I have if this makes your life easier.
Grant and Michelle, you know your trial order second. All right, thank you guys. All right, on the 9:30, everybody ready? Come on up, please. Spodak versus Cooper. Your Honor, that's why I'm here. Okay, wonderful. Thank you so much. I can't ex parte you. I'm so sorry.
It's service. It keeps doing this to me.
He's not here. So sorry. You need to talk to
And
the.
we just, if I wasn't here, you'd rule against me when I wasn't here.
Have a great day, sir. All right, thank you so much. Spodak versus Cooper, please. All right, good morning, everyone. We have our court order. And good morning. We are here on Spodak versus Cooper. Could counsel please state their appearances for the record?
Good morning, Your Honor. Katie Merwin on behalf of the counter-defendant, Craig Spodak and Spodak Dental Group.
Good morning, Your Honor. Attorney Malatesta on behalf of Cooper, the defendant / counter plaintiff.
Good morning, Your Honor. Wayne Kaplan, also on behalf of Dr. Spodak.
All right, good morning. Very nice to see you, everyone. Ms. Merwin, this is your motion to dismiss, and I had a chance to read it, and you may proceed when you're ready.
Yes, Your Honor. Do you mind if I argue from the...
Absolutely.
Thank you. Sorry, I just had a lot of...
No problems.
I'm going to go back to
Sure. Make yourself comfortable. No problem at all.
Thank you, Your Honor. So we're here on the counterclaim that was filed by the plaintiff, Jessica Cooper, in response to the original complaint that was filed by the plaintiffs, which include various counts for defamation and for torturous interference. The counterclaim asserts various counts for battery, unpaid wages, and retaliation under ERISA. There was also a conversion claim, and their response in opposition plaintiff conceded, so I'm not going to argue as to that.
That was off the table, I think.
And so initially with the battery complaint in the counterclaim involves a fragrance machine. Just for a little bit of background, this is the same fragrance machines used in hospitals, used in Westin hotels, and the plaintiff claims that the particles emitted from the fragrance machine caused an allergic reaction, and so this is a battery. It's really an ADA claim couched in a battery claim, and what's missing here is the intent. You know, there's an intent requirement. Certainly, you don't pay thousands of dollars to use a fragrance machine for your patients with the intent of causing harm. And there's I think a particularly I can never say that word right, analogous case. It's a federal case, it's out of district. Candidly, I couldn't find any
Sure, yeah, this
issue.
is an unusual factual circumstance.
Yes, and it involves smoking a cigarette.
Okay.
And in that case, the employee would smoke a cigarette, blow smoke on another employee, and they said, you know I don't like that, you know it caused me to cough, that's a battery. And what the court said is, no, the person's not smoking just to cause a battery. You don't smoke to upset somebody else, you smoke because you're getting some benefit of it. And so that wasn't enough to cause a battery. And then I cited another example where wearing perfume wasn't sufficient, even if it did cause an allergic reaction. So, while I admit that there's not Florida case law on it, I think the Florida case law explaining intent is directly on point.
And let me ask counsel, this is an unusual situation.
Your
How
Honor,
is this a battery?
it certainly is an unusual situation, but I think the battery comes into play where first of all, we would disagree on whether the fragrance machine is reputable and it's a quality product.
That's a factual dispute, yeah.
But it was installed in January of 2017, thereabout. It was turned off at the behest of the employees in an agreement between Cooper, other employees, and Dental Group, the employer in the case. It was turned back on in secret, and I don't think I pled this properly, and I acknowledge and I realize that, but they lied about it for 3 or 4 months between November of 2017 and January of 2018. And it is that deceit coupled with the clear manifestations of harm in Cooper and other employees, although Cooper is relevant.
Where's the intent element?
The intent
a battery is an intentional tort.
It would be the intentionally releasing something they agreed not to, and then lying about whether they were releasing it into the atmosphere so that my client wasn't aware it was without her knowledge.
But this is particles. This is not it's not a physical act. It's not, and I'm not aware of any situation where releasing particles would be a battery.
I would, there's not a lot of good case law on that.
I've never heard of such a thing.
I would characterize it as a chemical that was released into
But
the air.
maybe it would be a chemical, maybe analogous if it was an intentional chemical spill or someone threw something, potentially I could see it. But this is a diffuse product in the air, and I don't understand why it's directed towards somebody.
I think we could argue about whether it was diffused or whether maybe there was improperly
But how is it
installed.
directed or intended to physically touch her?
It was intended to be in her workspace, and it was pumped throughout the workspace, and then it kept getting increased and causing additional harm.
Okay, I'm going to grant the motion to dismiss because I'll grant it without prejudice, but I'm not aware of anything. I think Ms. Merwin's analogous case is exactly on point. I think there has to be an intent element that you need to show, and that's not pleasure. All right, let's do the next one.
Thank you. I will say there's another aspect to the battery. If it's dismissed and he's going to replay it, I can...
I'm going to give him leave to amend. Let's see if you can come up with something, maybe... I'm not sure what we can come up with, but let's think about it, okay?
All right, sure. The next aspect is the wages. Now, she's claiming unpaid wages. I think she puts a dollar figure, she's owed $4,000 in past due wages. Under the statute, before you file a claim, you have to file a notice, and it has to say, I'm going to sue you.
Absolutely.
Here are the amount I'm owed. Here are the hours I worked. Here are the dates I worked. We don't have that.
Yeah.
It's not attached to the complaint. It's not, they generally say, oh, I sent the notice, but I don't have it anymore, back in 2017.
Was the notice delivered?
Absolutely, Your Honor, it was. It was delivered through the defendant's email system, and there were at least half a dozen emails that were sent.
Does it strictly comply with the statute?
It does not strictly apply with the statute, but I don't believe the case law supports a strict application of the statute.
Did you allege all the elements of the statute requires? Because the reason the statute has this is because it's to give employers an opportunity to pay.
Very briefly, Your Honor, on the back of my response, I included a copy of an email we were able to identify through the course of discovery, and it's like a forward of a forward, but essentially it identifies 274 hours. It points the defendant to their own system. It says she was owed $15 an hour. Now, it doesn't say that she intends to sue, but I don't believe that's a requirement. It just says, I'm owed.
Motion to dismiss is granted. It's a pre-suit requirement. You gotta comply with statutes.
And Your Honor, I'd ask that it be dismissed with prejudice. The case law I have says this is not something
You
that you can cure.
have to have,
Your Honor, before you dismiss the case with prejudice, I really don't believe that, and I can get you more case law on this.
Okay,
but
I'll dismiss it without prejudice, but I think defense counsel's right. That's a pre-suit requirement. I used to practice in this area of law and business litigation. It's a pre-suit requirement, but I'll give you leave to amend if you can
I
find
don't
something.
believe the statute or case law requires her to say, I'm going to sue you. I honestly don't. It just has to say, this is a demand, Your Honor.
And Your Honor, if you want to take a look at the email, I actually cited my motion. It's not directed to Spodak. It's directed to her husband. There is, and if he's talking about something else, I haven't seen it.
Did it go to Spodak?
Yes, it did, Your Honor.
Can
But
I see
the
it?
problem is,
Because I specifically asked him what is the notice, and what he provided me is an email she sent her husband.
That doesn't go to Spodak. You can't fix that.
Your Honor, it does. It goes to Kathy Miller with Spodak Dent, who was responsible for these type of payroll issues. And there was an in-person meeting and multiple emails. It's different than what I showed opposing counsel during our conversation.
Okay, then you're going to need to allege it in your complaint anyway, so motion to dismiss is granted. Let's do the next one. You're going to say you have to comply with statute. When was the demand set? What was put in the demand? That kind of stuff. And that needs to be alleged in your count for unpaid wages. Okay, all right, let's do the next one.
Sure. And the last one is a claim for retaliation under ERISA. So what happened, and again, this isn't, and it's in the complaint, it's in the counterclaim, but just for background, there was a glitch, and Kathy Miller took responsibility for it, where not just Jessica Cooper, but all of the employees, including Dr. Spodak, all of the dentists, their contributions weren't timely contributed. Ms. Cooper brought it to our attention, and immediately we rectified it. And it took acknowledgement of the issue. Kathy said this was my fault. We're working to get you paid. There was they notified the DOL. We worked with the DOL. Cooper wasn't satisfied that the only penalty we had was to pay the interest, which we said we would do right away. And so she went, and this is to the complaint, she went on a smear campaign. And Your Honor, for illustrative purposes, I brought a copy of the complaint. I mean, hundreds of statements saying Spodak's a thief. They steal from their employees. They're embezzling. That's the basis of the counterclaim. I mean, hundreds of communications directly to patients, directly on Facebook. And why that's important is because they're claiming that the lawsuit we filed was retaliatory. And you can't do that because it's protected. I've argued that the Florida litigation applies, and there is 11th Circuit case law applying that. I will say that's more murky. And so I would say let's go just the Norrie-Pennington doctrine, because there's no question of that applicability. The Norrie-Pennington doctrine is essentially the same as the litigation privilege, except it has exceptions. There can be no question, that's the law in the 11th Circuit, that if you petition the government, whether it's in state or federal court, that cannot serve as a basis for a retaliation claim. And it started off as antitrust. It's been expanded to any single lawsuit. And so to defeat that, the plaintiff has alleged, or the counterplaintiff has alleged, that it's a sham pleading. And that's certainly an exception under Norrie-Pennington doctrine. But in order to be a sham, the plaintiff has to specifically allege facts that demonstrate it's objectively baseless. It's frivolous. There's lacking any probable cause. The test is no reasonable litigant could ever conceive of succeeding on the merits. So it's not enough that, even if we lose, that's not enough. The fact that they have affirmative defenses, that's not enough. There has to be objective evidence specifically pled in the counterclaim to establish a sham. And if not, I've provided about 5 or 6 different federal court at the motion to dismiss level, granting motions to dismiss, and most of them with prejudice, because you don't want to keep affect somebody's First Amendment right to petition the government. And the counterplaintiff acknowledges there's no other basis for retaliation than filing the complaint at issue.
Okay, all right, response please.
very briefly on the Florida litigation privilege, Your Honor, I did not address that in my original response, and I sent something late last night.
Sure, I didn't see. Let me see what you got.
So, Your Honor, this is a case by the same court that made the only citing federal authority by the moving party that the Florida litigation privilege applies to federal claims of retaliation under federal statutes. They threw out their own decision. So it's not just murky, it literally is, it was thrown out by the same court. So moving on to the Norrie-Pennington doctrine, we can get into a factual discussion of the baselessness for an illustration of a point where they said they rectified it. This was filed in, I believe, July or August. She didn't finish getting paid until September.
Okay.
They had ignored her responses until she got the federal government involved. They have...
Well, what about the standard? Ms. Merwin's saying it's such a high standard in terms of what needs to be alleged.
I would disagree. What do you mean by standard?
I mean, in terms of what needs to be alleged, and yeah, so...
We allege that they cannot bring a on a good faith basis that any of the alleged defamatory statements are objectively false. And that's a factual question. Each and every one, we can go A through whatever if you want.
It's not procedurally appropriate this time. Let me hear rebuttal, please.
Sure, Your Honor, what the case law says is that it is actually appropriate on a motion to dismiss, and it's not enough that there's factual defenses, and the entire complaint has to be a sham. There's allegations of defamation in our complaint that far exceed just the lying or thieves. And actually taking it a step further, even if what she's saying was true, is bad faith, because she already knows that it was the result of Kathy Miller.
That's the entire basis a sham.
And I would also say that they only offer conclusive allegations in the counterclaim, and that, again, every single case I've cited in my reply, and I can go through and say that's
If you'd like 200 or 300 pages going at each and every alleged defamatory statement and trying to prove that it wasn't false, I mean, we can get into a summary judgment.
You can do whatever you want to at that point, but my question is, how is the entire complaint a sham?
Let's go line by line then, Your Honor, because they're claiming that these, for example, number one, it says Spodak even deleted transactions from 3 weeks ago showing they're reversed. We emailed them both transaction reports after we provided the notice of reverse transactions on our 401k account. That's a true statement.
Okay.
We can go through each and every one, and I can provide you the evidence.
But the entirety of it has to be sham. That's the standard.
It is. It
and
is.
he may win.
Yeah.
What the standard is, and I think the Sable Palms case is particularly reflective, because I can't say analogous, right, is that if I can get up in front of Your Honor and argue with a straight face, it's not objectively baseless.
I mean, that's my question. It's a high burden for you.
Then let's go through it, Your Honor. Because I'm telling you that each and every line item, it's not objectively false statement of fact, or it's not made by Cooper, or it's a statement of opinion. None of this is false. I'm not saying it's not inflammatory, but none of it's false. And if you bring this type of...
That's not what we're doing. It has to be now.
And on top of that, again, it's probable cause. If we have probable cause, if they took issue, they could have moved to dismiss.
Yeah, it could be anything. It could be just what they've alleged. That's what I'm thinking.
Again, Your Honor, there's nothing... They cannot... So again, their factual pleadings do not receive deference in consideration of whether or not it's a basis.
I'm not giving the deference. That's not the standard. There's not deference. It's just probable cause. That's the standard.
I don't think they have probable cause either, Your Honor. And we can go through and discuss each of these alleged...
Anything that they've alleged.
Nothing.
He could have moved to dismiss. If it was that clear on if it had absolutely baseless, it would be the subject of a motion to dismiss. And that's where the Supreme
I'm going to
Court...
grant the motion to dismiss on that count, but I'm going to grant it without prejudice. I don't know what you're going to allege here. This is going to be really tough for you to be able to meet this one. So, but I'm going to leave to amend.
I would like the opportunity to go through each one then.
But not today. We're going to amend it.
So are you looking for me to attach 100 pages to the complaint?
I want you to do whatever you need to do, but at this point in time, you haven't met the requirement under the case law. A motion to dismiss is granted. How much time do you need to amend?
3 weeks, Your Honor.
3 weeks? Is that it? Well, thank you guys. Great work. All right, let me know when we're ready on the 10 o'clock.
I have a blank order.
You can do it now or email, whatever's
Your Honor,
easier.
I would just ask that before we do this again, we do go through each and every one, and we can talk about how it's baseless.
I want you to look at the case law counsel, because this is very unusual to have this type. Look at the counts.
It's absolutely not, Your Honor. The Noer-Pennington Doctrine does not have any case law on the ERISA issue of dismissing this type of case. When my client alleged something like this, I completely disagree, but we can go through it.
I'll give you 3 weeks to amend. Thank you guys. Have a great day, everyone. Thank y'all.
Thank you.